Hello and welcome to today's presentation on statements as evidence, drafting and editing declarations, affidavits, and letters in immigration cases. This presentation is brought to you by the American Bar Association's Commission on Immigration. My name is Dina Sharouk, and I'm a senior legal advisor to the Commission. Today's presentation is going to discuss written statements as evidence, types of written statements that one can use before USCIS and the Immigration Court, who makes statements in immigration cases, and the process of drafting and editing written statements. We'll be discussing structure, level of detail, ethical considerations, and a lawyer's role in the drafting and editing process. Finally, we'll end the presentation by discussing some resources. So let's talk a little bit about written statements as evidence. Written statements are informative and critical pieces of evidence in many immigration cases. Oftentimes, they may be the only form of evidence available in proving a prima facie case. For example, in a Cuban asylum case, evidence might not be available. It might be difficult to pull an official record, such as a death record or a birth record. In a case like that, one may have to rely heavily on, if not solely on, a written statement. The primary goal of a written statement is to prove or corroborate a client's case. It's advisable for an attorney to return to the elements that they have to prove and catalog what pieces of evidence they have or could memorialize to prove one or more elements of the case. Another important goal of a written statement as a form of evidence is to provide the fact finder with a client's account. Demonstrating credibility is crucial in immigration cases, and written statements can lend themselves to a client's credibility if the client is testifying consistently with that written record or with that written statement. And finally, good moral character is sometimes an element of an immigration case. But likability also has the propensity to influence a fact finder. So written statements really are an opportunity to offer insight into who your client is on a human level. So let's talk about different types of written statements. Here we're going to talk a little bit about affidavits and declarations. And these two are often conflated, but there are some technical differences between them. Affidavits are first-person accounts of information known firsthand by the person who is swearing to that affidavit. Which brings us to our next point. Affidavits have to be sworn and notarized to be affidavits. Affidavits are generally given the highest weight because, by definition, they have to be sworn and notarized. The Immigration Court Practice Manual offers swearing language for an affidavit. It's generally I declare or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct to the best of my knowledge, information, and belief. Declarations similarly are first-person accounts of information known firsthand by the person who is providing that declaration. Now, declarations may be sworn or notarized, but they're given a high weight if they are sworn. So for the purposes of this presentation, we'd really like to focus on sworn declarations because we want them to carry that high weight before the fact finder. We want the fact finder to look at these documents and say, well, that person just swore under penalty of perjury that this is true, so I'm more likely to believe that this is true. There are other forms of written statements, including letters, reports, and records. Letters are generally first-person accounts. They may contain some information that was provided to the person writing to the letter, so it might not all be first-hand knowledge. Letters should be signed and dated, and they're generally given some weight, but because they're not sworn under the penalty of perjury, because they're not notarized, they're given less weight than an affidavit or a declaration. Reports and records are narratives, forms, or studies that are created generally by experts. Some may be published. Some may be kept in the regular course of business. So, for example, a medical report might just be generally kept at a hospital or in a medical records department. Some reports may be created by NGOs or agencies, such as country condition reports. So the weight really depends on the content and the contexts surrounding the production of that report or record. Reports and records generally aren't produced for the purposes of litigation, whereas letters might be, affidavits and declarations generally are being produced for the purposes of litigation. Reports and records usually just exist in the regular course of someone's profession, for example, medical records or country condition reports. So now we've seen the different forms that these written statements can make, and one may be thinking, all right, well, I'm just going to get a series of affidavits. And that's fine. It's fine to get a series of affidavits, but there are some considerations when determining the form that a statement could or should take. The first question is, who's making the statement? Who's making the statement plays a large role in what form it should take, and we're going to explain that a little bit more shortly. What is the content? So we talked about weight, and the question is how much weight the contents of a statement need to take to create the strongest case. We're generally inclined to make sure every document is a high weight document, but different documents may offer different values, and procuring sworn statements or notarized sworn statements can be complicated in some contexts. Additionally, in some cases, resources and time may be a factor when assessing weight and value of a document. Let's consider, for example, a letter from a member of a clergy discussing the character of a respondent or the role that that respondent plays in the community. In a case where good moral character of the respondent isn't really a concern, you may ask yourself whether or not that statement needs to be an extensive affidavit or if it can reasonably take the form of a letter. An important point here is to consider necessity and relevance. All pieces of evidence must be relevant to a case, and that means that they must make an elemental fact more or less likely. What elements of the relief does the content support? This is a consideration when determining whether or not this needs to be a high weight document. Is this the only piece of evidence that supports that particular element? Is it likely that that element is going to be challenged? And then there's the question of whether the statement is necessary or critical to the case, or is there an alternative piece of evidence supporting the same element? So let's talk a little bit about who makes statements in immigration cases. So here we have our main characters, our stars, the respondent, the applicant, and the derivative. The respondent is a person who is the subject of the immigration proceedings before an immigration court. Respondents are often seeking immigration relief defensively, and that's just to say that they've usually been put in removal proceedings and that they are defending themselves by seeking a certain type of relief. Typically, for family groups, there is one person designated as the lead respondent, and the rest are labeled rider respondents. And those labels aren't to say who has the strongest case necessarily. The lead respondent is often an adult. An applicant is an individual who applies for an immigration benefit from U.S. Citizenship and Immigration Services, or USCIS. These applications are generally filed affirmatively, and that's to say that one affirmatively takes the step to apply as opposed to defending themselves by seeking a certain form of relief. And finally, you have the derivative. And a derivative is a person who receives or is eligible to receive an immigration benefit because the individual is a qualifying immediate family member of the respondent or applicant. So, in a case where, for example, you have a mother with her minor son, both in removal proceedings, and mom qualifies for asylum and is granted asylum, her son, her minor son, is a qualifying derivative to receive asylum. So just because he doesn't have a claim for asylum independently, he can still get asylum through his mother. Who qualifies as a derivative depends on the type of case and age and marital status of the applicant or respondent. Other folks who typically make statements in immigration cases are witnesses, and there are different types of witnesses. You have your eyewitness, somebody who is present or observed an element of a client's case and then can corroborate the client's claim, such as a neighbor who saw and heard the client's physical and emotional abuse at the hands of a client's partner. Eyewitnesses were there and witnessed a particular event. When deciding the form that a statement that an eyewitness should take, you'll want to consider the value it has in a case. The higher the value in the case, the more likely you'll want a form that takes a higher weight. So, for example, in an asylum case, your client may have been attacked in the street while walking with a friend. Her friend may act as an eyewitness and submit a statement of what she saw to the court. This supports your client's assertion that she was attacked in the street. And because this is an asylum case, this attack might be used to prove the element of persecution. That's a high value in a case, so you may want to aim for an affidavit or a sworn declaration. You will want to do this kind of fact-specific analysis whenever you're deciding on the form of a particular statement. And then you have an outcry witness. An outcry witness is a person who was present in the aftermath of a critical and relevant event, such as a close friend who a client confided in about, for example, torture that the client suffered at the hands of the police. So, an outcry witness is a person who was present in the aftermath of a relevant event. In our last example, we had our asylum seeking client who was attacked in the street. But let's say in this case, her friend wasn't with her, but our client fled to her friend's house and told her what happened. Now that friend can produce a statement about what the client told her, how the client appeared, and what the friend observed: bruises, scrapes, blood, etc. There are also character witnesses, and I think we touched on this a little earlier. A character witness is a person who's not a party and can confirm that the client has good moral character. This might be somebody like a coworker. This could be a member of the clergy. Character witnesses generally confirm the applicant or respondent's good character, and the value of a character witness statement usually grows if you have to mitigate negative factors from your client's past. So, for example, let's say your client had a DUI 10 years ago. You may want a witness who has known your client, knew about the DUI, and saw your client's personal growth and rehabilitation since then. You may want the witness to discuss your client's attributes and how she is law-abiding. Now, if your client had no criminal charges or history that negatively reflects on her character, a character witness is still valuable, but perhaps not as critical as in a case where there are what a tribunal might regard as negative character factors. These are not factors as to whether or not you want to include character evidence. This is a question of what form the statement should take. So where a character witness is mitigating those negative attributes, one may opt for a statement of higher weight. A chain of custody witness is someone who obtains a document or a piece of evidence on behalf of a client and can describe how they obtained it. Oftentimes, it's your client who procures and can attest to how she's obtained a particular document, either in written or oral testimony. But other times, a third party collects a document. For example, let's say we have a client who is a political dissident in her home country. She can't collect evidence of her wrongful arrest for protesting. So perhaps she relied on a lawyer in her home country to collect a police report or prison record. That lawyer could also produce a statement along with the document saying how he collected the record. This is particularly important in cases where a document's authenticity could be questioned. And still in the vein of witnesses, we will now discuss some experts in immigration cases. And folks often rely on experts in immigration cases, especially cases that have fear-based claims. So an expert is generally a disinterested party who possesses extensive professional knowledge, skill, experience, training, or education in a particular subject area, and they offer that expertise that is both reliable and relevant to the case, such that they're able to offer an informed opinion on the elements of the case. There is a really important case from the Board of Immigration Appeals called matter of JGT that discusses how to go about establishing an expert as an expert, and if one does employ an expert in an immigration case, and one will want to establish that their expert has met the requirements of being considered an expert before the immigration court. So let's talk about different types of experts. You have the medical expert, and medical experts can corroborate cognitive or physical impediments. They can corroborate physiological evidence that a certain event likely occurred. And medical experts can attest to scars or bruises or ongoing injuries that likely derive from a form of persecution, such as sexual assault or torture. And medical experts commonly produce declarations, reports, and records. These are frequently used in fear-based cases where severe violence took place. For example, in a Convention Against Torture case, somebody may rely on a medical expert to testify to a person's injuries being consistent with torture. Country condition experts can corroborate patterns, practices, attitudes, and behaviors in a country, region, tribe, and how that may impact the client. Country conditions experts can confirm the general conditions and treatment of a specific group of people. For example, somebody may qualify as an expert to discuss how transgender women in El Salvador are generally treated and regarded. Country condition experts often provide declarations, but there are also country condition reports which are standalone documents. For example, Human Rights Watch and the U.S. State Department often issue human rights reports. There are also broadly used and widely circulated expert declarations, which are generally treated like reports since they don't specifically speak to the case at hand. Finally, you have your psychological expert, and psychological experts can provide insight into a client's mental health. Psychological experts can corroborate prior events and explain how trauma history may impact the client's memory or ability to testify. The evidence that a psychological expert can provide can be used to demonstrate that any trauma is a likely consequence of an event, as well as explain any difficulty that your client may have in the course of testifying. Psychological experts often produce a declaration, a report, and in some cases, letters. Let's talk a bit about drafting and editing statements. At the end of the day, a practitioner will want to collect as much solid and reputable evidence as possible to prove all of the elements of the case. When assessing whether a statement should be either an affidavit, which again carries a lot of weight, or a letter, which has less weight, you'll consider the value and importance of that piece of evidence in making the case. You may be inclined to make sure every statement is an affidavit, and that's certainly fine. But there are times when a witness is less available, less willing to get something notarized, less able to participate in crafting of an affidavit, and you will have to weigh the availability of resources and time as factors in these decisions. So again, you'll consider the elements of the prima facie case and know which elements are adequately captured. The written statements must be a faithful account of the individual's actual experiences. And part of maintaining that is maintaining an individual's voice. So, writing a statement that's faithful to the way that that person speaks or relays information or processes information. If a witness or a respondent or an applicant is providing information in a way that isn't particularly clear, the practitioner will want to probe further to clarify any missing or confusing or incredible information. That is a way to maintain the individual's voice, but also to make it digestible for the person who is reading the document, for a fact finder. You'll also want to explore facts that are harmful to a client's case and assess whether or not you would like to address those statements head on in a witness statement. So let's talk about some considerations when drafting statements. The goal is to prove or corroborate a client's claim. We can't stress that enough. Client and witness statements should not include any legal arguments. Again, you want to be faithful to that individual's account and that individual's voice, and they don't need to make legal arguments. They're there to present the facts. A brief or oral arguments are a place where legal argument should arise. And statements have the ability to elicit an emotional response in the reader. That is of value, especially in cases that are discretionary. When an attorney is going through the process of helping to draft or edit a statement, they can use that process as a way to anticipate the case's weaknesses. So if, for example, you have a client who is seeking asylum and they're able to attest to their persecution and they're able to attest that they are a member of a protected class, but they can't establish that the persecution was because they are a member of that protected class, then you have a nexus issue. And the process of interviewing clients and seeking the facts through those statements can highlight some of the weaknesses in a case and can also inspire further investigation and the collection of further evidence. Another important point when collecting evidence and drafting statements is that statements should be consistent both internal to the document and across other forms of evidence. For example, let's say our client says that she was attacked on July 4th, but her friend thinks the day of the attack was actually July 2nd. If your client and the witness are unable to confidently provide the same date, they may consider giving broader descriptions of the occurrence of the attack, for example, early July. And discrepancies of a minor nature are really quite common just by virtue of the way that people remember events. But this, of course, presumes that everyone is doing their best to remember things as they actually occurred. Practitioners cannot ethically present evidence that they know to be false or misleading. Let's talk a little bit about interpretation and translation services. A word-for-word interpretation is always best. Otherwise, you may miss something in what your client is trying to express to you. Also, you'll otherwise be relying on an interpreter's own reading of what's being said as opposed to those literal words. If possible, one should use multiple interpreters in different instances to capture the voice of your client and to prepare your client for any kind of government appointed interpreter later down the line. So once the statement has been drafted with the help of the attorney, the interpreter could read the statement in its entirety in the client's primary language, or the interpreter or translator could actually translate the statement into the client's preferred written language and present the document to the client to review. Both options are technically acceptable, but if you're dealing with a literate and competent client, there are benefits to having the document translated because then the client has more time to review and process that document as opposed to simply receiving an oral interpretation. So let's talk a little bit about the structure of an affidavit or a declaration. The title of the document should be listed at the top of the first page. With respect to introductory paragraphs, some practitioners may start with simply offering biographical information, while others may present a brief basis for the claim. Both of those forms are perfectly acceptable. I will say that if you want to make a document more impactful, providing a brief basis for the claim or those facts up front can certainly have an effect on the reader. For example, instead of starting a document with, "My name is Jane Doe and I grew up in the country of Countrystan," a statement might be made more impactful if it began with, "My name is Jane Doe and I fled my country of Countrystan because my husband was trying to kill me." Many practitioners include the usage of headers throughout a statement as signposts for an adjudicator. This is particularly helpful as a way to frame content, but also as a way to combat some of the pitfalls of a fact finder who may be skimming the document as opposed to reading it very carefully. The contents order can vary depending on your client's recall. So remember, you want it to be authentic to your client, their voice, and how they think, while still making it accessible to the reader. Now, a lot of folks might order a statement chronologically, and that's certainly fine. But your client may not process or deliver information in a chronological order, and not every culture processes time the same way. So you don't necessarily want to force puzzle pieces to fit in a case like that. Some clients' accounts may lend themselves to ordering information by elements of the case. So let's talk about level of detail in statements. Your client's consistency is critical for credibility, so you generally do not want to offer details that vary when your client expresses them. Clients of varying backgrounds, of varying experiences, of varying memory capabilities or psychological capabilities or psychological trauma may present information in different ways at different times. These are considerations that a practitioner will want to reflect on when deciding the level of detail that should be provided within a written statement. On the other hand, if your client is very consistent and secure in how they discuss their experiences, there can be benefits in including detail, including lending themselves to credibility and eliciting a supportive emotional response from a fact finder. Regardless of a client's ability to consistently recall events, it can be a traumatic process for a client to revisit painful experiences. It's important for a practitioner to be aware of the pain that this process can cause, but also to educate a client as to the potential benefits of providing these details in written form. For example, a detailed account of a traumatic event could lead the Department of Homeland Security or an immigration judge to forego detailed testimony on a particular incident. Another step an advocate can take to mitigate the emotional harm caused by revisiting traumatic events is to suggest affordable mental health resources such as pro bono or low bono counselors. Presuming that you want to offer a higher level of detail because your client is consistent and able to provide those details, showing language is generally seen as stronger and more impactful than telling language. And what showing versus telling really means is instead of interpreting events, offering observations and sensations. So sensory details can be powerful. Instead of just saying, he attacked me because of my religion, offering the sensory details. He called me, insert whatever bigoted word here, as he slapped me with an open palm across the face. By offering those sensory details, that palm across the face, the sound that she remembers hearing, relying on any of her senses and what she still remembers from a particular incident, is more likely to be impactful in written form. Similarly, where possible, if a client can remember direct quotations, the use of quotes can be particularly impactful to a reader. Attorneys can ethically take a proactive role in interviewing clients or witnesses and doing the physical drafting and editing of their statements. But those statements have to be faithful to the subject's experiences, account, and voice. It is always important to balance the duty of candor toward a tribunal and the duty of offering competent and zealous representation to a client. Those two duties should not be in conflict. A practitioner has to embrace the facts that they are given and advocate for the client as best as they can. That being said, a practitioner simply cannot offer any evidence that they know to be false or misleading. And during that interviewing process with the client or a witness, a practitioner should not shy away from probing information that seems incredible. That's not to say that one should be interrogating a client or witness about their honesty, but one will need to inquire as to information that seems less believable or is missing information, because a fact finder or an opposing party will do just that. That's a critical step in assuring candor toward a tribunal and competent and zealous representation. Finally, there are a couple of resources we want to highlight for you. The American Bar Association's Commission on Immigration has created a practice guide on statements as evidence. That document goes into a lot of detail beyond what you've heard here in this presentation, and it's available on the Commission's website. Finally, we mentioned earlier the Department of Justice's Immigration Court Practice Manual is available online as well, and it contains important information regarding the structure of statements and evidence presented in the immigration court. We want to thank you for attending this presentation. Please do not hesitate to reach out to the Commission if you have any questions regarding this resource. Thank you again, and have a wonderful day.